Welcome to our White Collar Support Group's Tuesday night speaker series. We meet on one Tuesday night a month and we have guest speakers. And tonight we are thrilled to have three members of the Women's White Collar Defense Association, Caroline Ciriolo, Margaret Graham, and Jillian Berman, and they're going to be speaking tonight on restitution and forfeiture, which of course is a huge topic for people in our community and very misunderstood, kind of a mystery out there for a lot of people, including lawyers, by the way. I haven't met that many lawyers who really have a handle on restitution and forfeiture. So I'm sure we're going to learn a lot tonight. We've got a little housekeeping to do before we get into the presentation. I just want to make sure that I'm recording. Yep, I am. Our White Collar Support Group has been around for about 10 years. In fact, last night was a Monday night, and we had our 190th meeting. So we are steaming towards our 500th meeting. We meet every Monday at 7 p.m. Eastern, 4 p.m. Pacific. If you'd like to join our group or get more information, you can find it on our website. That's prisonist.org. That's prisonist, like feminist.org, probably appropriate for tonight. We have two speaker events coming up that are already planned. One for December, on December 9th, it's Doug Passon. He's a lawyer in Scottsdale, Arizona, and he's a sentencing and mitigation expert. So we're very happy to have him on Tuesday, December 9th. And on January 20th, we'll have our own Drew Chapin, who's going to be talking about online reputation management. And that's going to be skewed towards, not just towards justice impacted people, but also towards professionals, because definitely something that rounds out the offerings that attorneys and other professionals can give, because it's really hard to come home from prison and face all the obstacles that we face. And one of them, of course, is Google and ChatGPT, and the fact that our reputations are live online all the time, and no pardon, no expungement is going to stop that, at least as of right now. So how to manage reputations, it becomes incredibly important when we come home from prison. And Drew is going to talk about that on June 20th. But tonight we have some very special guests. Caroline Ciriolo, Margaret Graham, and Jillian Berman. They're former Department of Justice prosecutors who represent individuals and entities in government investigations and criminal regulatory matters. And they'll share their insights on forfeiture and restitution in federal criminal matters, including recent DOJ practices and strategic considerations on the defense side. Specific issues covered will include differences between forfeiture and restitution, the interplay between the two, valuation of assets, and what assets are subject to forfeiture and restitution, unique issues related to restitution to the IRS, and corresponding civil tax liabilities and strategies to limit potential exposure. That's a mouthful, but I'm sure we're going to learn a lot more than that. So I'm going to just turn the mic over to Jillian. Jillian, thank you so much for putting this together. So I'm going to turn it over to Caroline, Margaret, and Jillian, and they will present for as long as they do. We have a hard stop at 8:30. Somewhere around 7:50 or so, I'll put a prompt in the chat asking if you have questions, because I know Margaret has to leave early and she's going to be presenting on forfeiture. So take it away, and thank you so much for being here with us tonight.
Thank you. Hi, everyone. It's such a pleasure to be here. I'm Jillian, and you see on the screen Margaret and Caroline. Every time I say her name, I have to remind myself, is it Carolyn or Caroline? We are really thrilled to be here and get more involved with your organization, which sort of came on my radar more recently when Jeff came to the WWCDA, Women White Collar Defense Association, which all three of us are involved in, to sponsor and partner in the conference that you had recently in October. And we were thrilled to do so. And that thus led to this opportunity for us to speak to you about issues that we thought might be relevant to you. But I will note, and Caroline can tell you this herself, because she's been talking about your support group for a long time, to me and to others, because I know she has referred clients to the group, and speaks so highly of the resources and the support and all the network that you have built, Jeff. So thanks for having us. With very, very brief introductions, I'll tell you a little bit about ourselves and what we're going to cover tonight. These are very, very broad topics, and there are um, so many components of them, and we don't have all the answers. We hope we have a lot of information that will be useful to you. I will note that obviously we are not your lawyers. We are not here providing legal advice tonight. That would be malpractice. We don't know the individual situations that everyone is in, but we hope this is helpful and gives you um, a place to start when you're thinking through issues that might involve you or your family or loved ones, et cetera, if you're going through the criminal justice system. Um, I am in private practice. I've been in private practice for about, I don't know, 12 years, doing criminal defense work at a boutique law firm in New York called Lankler, Siffert and Wool. Before that, I was a federal prosecutor at the U.S. Attorney's Office in Manhattan. Um, I'll keep these introductions short, by the way, but you can find all of our bios online if you, or our emails. Margaret Graham, who is here, she's at a law firm called Latham and Watkins, and where she also does government investigations on the defense side, representing entities and individuals. Margaret was, of the three of us, the most recently in the Department of Justice as a federal prosecutor, also at the U.S. Attorney's Office for the Southern District of New York, where she was for almost 11 years in various roles, doing all sorts of cases, including securities fraud and other white collar cases. And her insight is particularly valuable because she is so recently, wore the hat of a government prosecutor, and so has a lot of visibility into what prosecutors are thinking, and that is something that we defense attorneys are always trying to do for our clients, think about how the government is thinking about these issues. And then Caroline, sorry, uh, Ciraolo is a partner at Kostelanetz in Washington, D.C., which has offices elsewhere. She was previously in the Department of Justice as acting assistant attorney general of the DOJ's tax division. So she has a particular expertise in tax cases, tax litigation, criminal and civil cases. She has very deep expertise in this regard. And has a lot of information about sort of the tax treatment of assets and other things that are subjected to forfeiture and or restitution orders, which very, very few people know much about, I will tell you. So it's a tremendous resource. So what we're going to do tonight, our agenda is principally to sort of talk about forfeiture first. Margaret is going to kick it off and talk about, but actually both forfeiture and restitution, and explain at a high level the difference. They are very, very different. So she will make sure you appreciate those distinctions. And she'll give some examples to make sure that's clear. I will then talk a little bit more about restitution and some more specific aspects of restitution, the kinds of things that courts can order restitution for, what it means, just some more details on that aspect of things. And then Caroline's going to talk also about restitution, really more on the collections angle and the IRS and tax implications of restitution awards. And then, as Jeff said, we will try to leave some time at the end for questions, which you should feel free to put in the chat as we go. So with that, we'll turn it over to Margaret.
Great. Thanks so much, Jillian. Like Jillian said, wonderful to be here speaking with all of you. So I'll be talking about forfeiture. As you've heard a few times now, and this is going to be a common theme, forfeiture fairly poorly understood, both by prosecutors and sometimes by defense attorneys. So I'll be talking about forfeiture and what it is how it's different from restitution, how the two interplay, and then a few parting thoughts about forfeiture specifically. So forfeiture, generally, you can think of it as the need to give up ill-gotten gains. So it's set by statute. There are different formulations. The exact words that apply and statute that applies will depend on the crime that you're charged with. But for most white-collar crimes, it means that the government can take property that was involved in a crime, either because it was used to commit a crime or because it represents proceeds of a crime. One caveat to that, if the charge is money laundering, they can actually take a broader set of property. It's any property involved in money laundering, not just proceeds, but property involved in. And the reason that's going to be broader is there's a theory that the government uses that to launder dirty money, you need to have clean money in the same account. And so under this theory, the government gets to seize not only the dirty money, but also the clean money. So that's why it's broader under money laundering. Okay, so high level, that's what forfeiture is. Forfeiture is very different from restitution. People often confuse them, including lawyers. Restitution is meant to make victims whole. It's also guided by statute, but different statutes, but it's really meant to make victims whole. It's compensatory. The money's meant to go to the victims. Forfeiture is meant to be punitive, and the government seizes and takes ownership of the money or the property. So I thought we could go through a few examples so everyone can understand how this can play out in practice, right? So let's think of a first example, because sometimes forfeiture and restitution amounts can be the same in a case, sometimes they can be different. So let's think of a first example. The government alleges that an investment advisor embezzled $100,000 from a client. Here, forfeiture is going to be $100,000. That's the ill-gotten gains that the investment advisor received from the client. Restitution is also going to be $100,000 because that's the money that the client lost, that the victim lost. So there it's pretty straightforward. It's the same amount. Now let's think of an example where they're going to be two wildly different amounts. Insider trading. The government alleges that an employee of, let's say, AT&T stole information from AT&T and traded on it. Here, forfeiture, the ill-gotten gains, are going to be the money that the defendant made trading. Restitution could be zero on the theory that it's pretty hard to say who the victim is of insider trading, right? The theory is it's the market writ large, but you can't really put a number on that. So it might be zero. It also, for reasons Jillian might explain, might actually be quite high if the government thinks of AT&T, the company whose information was stolen, as the victim. And their restitution could be the money that AT&T had to spend in attorney's fees figuring all of this out and dealing with this problem. So that's a second example. A third example, a situation where the government alleges that a trader at a company made much riskier trades than advertised to the clients. And as a result, the clients lost $1 billion. So you can tell, if you're following along, you can tell what restitution is going to be, right? It's the $1 billion that the clients lost. But forfeiture here, the trader never got that money, right? It's just money that the clients lost because the stock market took a tank, let's say in March 2020. So forfeiture here could be the bonus, the salary and the bonus that the trader made that year, right? On the theory that kind of he wasn't doing anything, you know, the management fees, like he didn't properly earn those. And so restitution could be huge, $1 billion, forfeiture could actually be a pretty small amount. So that's the different concepts. So a question that we get all the time is, let's take the first example, easy example, right? 100,000 was taken from a victim, went to the defendant. We now have two money judgments, right? One for forfeiture of 100,000, one for restitution of 100,000. The natural question is, does this mean that the government gets to double count and double collect? Is it entitled to both? Is it entitled to take $200,000? So the answer is yes, but the government is entitled to both forfeiture and restitution separately. They're different statutes. They serve different purposes. They go to different things. But in practice, what often happens is that it only collects once, and forfeited funds are applied to restitution obligations. This happens through an internal DOJ process called restoration. And in this situation, it would mean that once $100,000 has been forfeited, the defendant applies for that money to be applied also to the restitution obligations. So only $100,000 is paid. Now, like I said, it's an internal DOJ process. It is not something that gets wrapped up as part of the criminal case, because the people who decide whether restitution will happen are not the prosecutors who are handling any individual criminal case. In fact, they're not allowed to promise what the outcome of any restoration request will be. That's because the people who decide restoration are at Main Justice, are at DOJ in DC in a specialized unit called Money Laundering and Asset Recovery Section, MLARS. They are the sole decision maker. And so often, in fact, usually, their restoration gets decided only after a criminal case has ended. So that's an important thing to understand. A few additional points about forfeiture that I often get questions about, and then I'll hand it over to Jillian. I often get questions about what happens if the government alleges that criminal proceeds went into my bank account, let's say 2 years ago, right? Some number of times ago, some amount of time ago. And since then, there have been a bunch of transactions. How successfully can I argue that that's not the criminal proceeds anymore? And the answer is, you may be able to successfully argue that. The government cannot just say, in 2022, 200,000 of criminal proceeds went into account X. There's now $400,000 in account X, therefore I get to take 200,000. They have to show that the money in the account today that they want to seize is traceable to the criminal proceeds. That is really complicated. It often involves experts. It's too complicated to explain here, but I just wanted to explain in general the concept that it has to be traced. Another important practice point: forfeiture is mandatory in all criminal cases, but the government often has broad discretion to negotiate the amount down. This is kind of you can think of it as a bird in a hand versus two in the bush situation. Sometimes defense attorneys and defendants are successful at negotiating if the government decides what should be forfeited is 900,000, but there's 300,000 that can be turned over right now, and I'm using these numbers as examples, obviously. The government will sometimes agree to accept that smaller amount paid now in full satisfaction of the forfeiture amount. That's generally negotiated as part of a plea agreement. So that's a situation where negotiation is possible. One other thing that I want to briefly mention. So far, we've been discussing criminal forfeiture, which happens and is attached to criminal cases. The government seeks forfeiture in the indictment. It's included in a plea agreement if a plea agreement happens and the judge orders it at sentencing. There's also something called civil forfeiture. It's typically used where there's no criminal case and no other way to recover property that the government wants to forfeit, say a bank account, say cryptocurrency that's sitting in a wallet, say a house. I mention it only so that you're aware that it exists. Like I said, if there is an ongoing criminal case, the government prefers to handle forfeiture that way. And so it may be that this is not relevant to all of you, but there is something called civil forfeiture. You'll know about it because it will be a separate action, and they often sound a little bit silly to lay people or even to lawyers. It's something like United States versus $453,000, or United States versus 25 Bitcoin, or United States versus, 15 Monroe Avenue. So that is going to be civil forfeiture. But if there's a criminal case, like I said, forfeiture will usually happen criminally. One last insight into how forfeiture works. Like Jeff said at the beginning, forfeiture is often poorly understood by lawyers. The prosecutor handling any individual case may have limited experience with forfeiture. I think it's important to understand that. Defense attorneys may have limited exposure to experience with forfeiture. There's actually a fantastic publicly available online resource called the MLARS Asset Forfeiture Manual. Like I said, MLARS, it's the specialized unit within DOJ that handles forfeiture issues and the restoration process. Their manual is online on their website. It is very transparent about their own policies and practices, and DOJ's policies and practices around forfeiture issues. And so I offer that as a resource to everyone. So now that I've covered unbelievably complex issues in 15 minutes, hopefully you're not more confused than when I started, but I'll hand it over to Jillian.
Thank you, Margaret. I think I don't want to say I'm confused, because that was all so clear, but these topics, every time I hear people talk about it, I'm reminded of how complicated it is. And to Margaret's point, many prosecutors are not particularly knowledgeable about these issues. And that is in part because different offices sometimes divide responsibilities. Margaret talked about the unit down in Washington, MLARS, which handles the restoration issues, but there's a lot of division. So you'll have like a U.S. attorney's office that might bring a case against someone and then get a forfeiture order and get a restitution order. And then the forfeiture is going to be potentially handled, or aspects of it handled, down in Washington. The restitution and sometimes the forfeiture is also often handled by a separate unit at the U.S. Attorney's Office, called the Financial Litigation Unit. So there's a lot of disconnect, which results in a situation where you have people wielding quite significant power, but they don't always understand all the nuances, which is why it's helpful for you to educate yourselves as best you can. Unlike this very useful manual that Margaret just described that is available online about forfeiture, in my experience, there isn't a ton of really good resources available on restitution and sort of how it sort of works from beginning to end. So I'll give you a little bit more information on that. And some of these are sort of issue spotting things to think about if you are in a case and where there is a financial component of restitution as well as forfeiture. So most of us, we practice mostly white collar, and that is mostly much of what we prosecuted as prosecutors. The principal statute, I would say, that authorizes restitution in white collar cases is a statute called the Mandatory Victims Restitution Act, which is, I won't give you the statutory provisions. But that is the principal statute that would apply in wire fraud cases, and other bank fraud, conspiracy to some, various securities fraud types of cases. And that statute does mandate restitution, with a few important exceptions in cases that are where that statute is applicable. And it mandates when there is a restitution award under the MVRA, it is valid for 20 years from the entry of judgment, or the release from imprisonment, whichever is later. This statute came after an earlier statute that made restitution where restitution was permissive but not mandatory. So courts did not have to order restitution. And like Margaret said, the concept of restitution is to make whole victims of the offense of conviction. Whereas, as she said, forfeiture is to sort of take away any ill-gotten gains. So they are conceptually very different. A court is not authorized to consider a defendant's economic situation in determining the amount of restitution that is going to be awarded. It can, however, consider economic situation in determining sort of a schedule of payments. But that is important to note, and that is why you often see very, very substantial restitution orders entered that will never be collected. It's not realistic. The burden of proof, and I'll talk a little bit more about this at the end when I talk about sort of a recent and potentially current development, but currently the burden of proof in terms of restitution is a preponderance of the evidence. So as you likely know, to be convicted of a criminal case, the government needs to prove guilt beyond a reasonable doubt. But that is not true for the restitution component, which often comes at the end of a case and is often sort of handled as an afterthought, though it shouldn't be. And again, it's only a preponderance of the evidence. And so typically what you have is the government is putting forward on behalf of victims the amount of losses the victims claim to have incurred, and seeking the court to impose a restitution order in the amount of those losses against a defendant. Who is entitled to restitution? It's a victim of the offense, not anybody. Many people could come forward and claim that they lost money, property, whatever, as a result of someone's conviction. But you have to be a victim of an offense in order for the court to find that you are entitled to restitution. A victim is defined as someone who's directly and proximately harmed as a result of the commission of the offense. And again, the offense has to be one for which restitution can be ordered. And I raise this because there are a number of cases that it is not infrequent for it to come up where someone may come forward and claim that they are a victim and they are entitled to restitution, but they may not be. And it might depend on, well, one, what was the offense of conviction, and is that an offense for which restitution is available, such that this person might qualify as a victim for a different kind of offense, but not this offense. Sometimes people come forward as victims, but there are some arguments or evidence that maybe they were involved in the situation. And so there could be a credible argument that rather than being a victim, they are someone who could have had culpability and therefore should not be entitled to restitution. So these are sort of important things for you to think about when and if people come forward claiming they are victims, and therefore their losses should be incurred by you in the form of a restitution order. It is important to consider whether, if you are in a case and someone is seeking restitution, usually through the mouth of the government, but on behalf of victims, it is important to determine if the statute at issue is one that authorizes restitution. And I say this because there was a recent case in Manhattan federal court where the case involved securities fraud, wire fraud, bank fraud, and charges were brought under both Title 18 of the Federal Code and Title 15. Title 18 is one for which restitution was available, but a substantive securities fraud charge, which is under Title 15, was not one for which restitution could be available. And so the court didn't order restitution in this case, and it wouldn't typically. I mean, there are arguments to be made, but typically it wouldn't order restitution in a Title 15 case. And this is relevant among other reasons, because obviously it would help limit exposure to restitution awards. It's also relevant because if you're involved in a case and you're thinking of negotiating a disposition, it's important to think, well, what are the consequences of any charge that I might consider pleading guilty to, or that I might be convicted of? It might be that if I plead guilty to an offense under this statute, I am subjected to restitution, whereas under another statute, I would not be. So those are important things to think about. So one very important exception where a court is not mandated to order restitution in a white collar case is where the number of victims or identifiable victims is so large that it makes restitution impracticable, or where imposing restitution would involve such complex issues of fact that relate to the amount of losses that effectively it might overcome this case. And so where there is such complexity or so many victims, a court might decide, and is authorized under the restitution statute, to say, effectively to say, it's too complicated, I'm not going to get to restitution. This happens sometimes in perhaps market manipulation cases where it's really, really difficult to determine if there was a stock drop, like what was the loss as a result of this offense. It's just kind of really hard to calculate, or it is really hard to determine who are the victims, or there are just so many victims. In the Sam Bankman-Fried case, and I know you had his dad on recently at the conference, like that is a case where the court did not actually order restitution, availing itself of this exception. Instead, it looked to use the billions of dollars of assets that were forfeited to try to satisfy losses for victims. But that's an important thing to think about, because it could be if you're a defendant and you are facing a very massive potential restitution award, it's a very viable argument to say to the court, this is too complicated. It will overwhelm the court's resources to even try to figure this out. One thing I want to touch upon is what is a loss? What is recoverable? And Margaret spoke to this a little bit. It's not limited to what you might assume it would be limited to. If a case involves a situation where someone is a victim, is out of pocket $100,000 that they invested, and the investment was taken and used for purposes that were not what they anticipated and resulted in a crime being charged, etc. You might expect that if convicted, the court might and you might expect to have to pay restitution to that victim who handed over $100,000 check that was then taken and used for purposes that were not intended. That is an out-of-pocket loss suffered by the victim as a result of the offense. One loss that has really ballooned, and we've seen it balloon in some cases, and I think is one that people might have no idea is coming, is that the statute, as interpreted by the Supreme Court, the Second Circuit, other courts, covers attorneys' fees incurred in responding to criminal investigations. And so in a lot of the kinds of cases we see, you have a government investigation. They send a subpoena to a company about certain conduct that an employee may have engaged in, or more broadly, the company hires a large law firm, spends millions of dollars on legal fees, responding, producing documents in response to a grand jury subpoena, making witnesses available to be interviewed by the U.S. Attorney's Office. And fast forward, when an employee of this company is convicted, the company can put in a claim for restitution for all of the legal fees it incurred in responding to the government's subpoena. and courts find that acceptable and viable. It is in the millions in many cases. It just happened in a very, very big case that was just concluded in the U.S. Attorney's Office in Manhattan. One of the defendants, Charlie Javits, it was a very large fraud that was charged where she sold her company to JP Morgan. The court ordered restitution against her and her co-defendant, I think to the tune of $115 million, which I think that amount was legal fees incurred. Not in fact, well, this was a very nuanced case, but this was a case in which the company had to pay her legal fees for contractual reasons. And ultimately the court ordered her, this is still a pending case, but the court ordered her and the co-defendant to effectively pay all that money back as a restitution, which this restitution order will be valid for 20 years from the date of release from prison. So these are things that you should be extremely mindful about. They are not always things you can protect against, but there are certainly strategic considerations to bear in mind as you're thinking about how to approach a case. Another aspect of restitution that I think is really important for people to remember and is not routinely employed, at least as I see anecdotally, is that a court can order restitution if in a case with multiple defendants, a court can order restitution jointly and severally as to all defendants in a case. So if you have a case that was brought with 4 individuals who are convicted, and different levels of culpability, different roles in the offense, and there's a $10 million loss ultimately to victims, the court can order all 4 of you to pay up to $10 million in restitution to the various victims of the offense, irrespective of level of culpability, irrespective of economic circumstances. However, the statute does specifically allow for the court to consider apportioning the restitution award and effectively saying, well, you each had either different levels of culpability or you have different economic circumstances. And the statute specifically contemplates that a court can consider economic circumstances when apportioning restitution. And the court could say, well, of this 10 million, there's one principal wrongdoer and you are responsible for 10 million. But, this person just got involved at the very end and didn't get anything out of this offense. And, all sorts of arguments could be made. You are only responsible for $200,000 of the 10 million total. So there are some creative ways to argue for the court to think about restitution where it can potentially cabin responsibility for one or some defendants in multi-defendant cases. And that I think is very important to think about. And courts I don't think it's done that much. And I don't think a lot of judges are that familiar with all of the ways they can approach restitution because it is so complicated. So it's important to think about. I just wanted to speak briefly to Margaret's when she talked about this process of restoration where forfeited assets can be applied towards a restitution order. They can, and as she explained, that's at the discretion of effectively DOJ down in Washington. And I think there are different views on how routinely that is done. In my personal experience, I have never had a situation where the government has applied forfeited assets from my client to a restitution award. And therefore, you have a situation where ill-gotten gains are taken from the defendant. He has to pay them, he or she has to pay them, but then there is a separate restitution award. And in at least my cases, that money that has been taken down in Washington in this, big pot of forfeited funds has not been applied to the victims. That is important to know. I mean, again, it can happen, it does happen, but it doesn't always happen, and it's not a guarantee. But I think that if you are involved in a criminal case, you should try to position yourself as best as possible to try to get that to happen, because obviously no one wants to double pay. And ultimately, victims are going to want to be paid. They're going to be clamoring to be paid, and they're going to come at you for anything they can if they don't get it from the forfeited funds. So these are conversations that can and should be had early on between defense counsel and the government. Will you at least try to recommend that AFMILs or MLARs down in Washington will take the forfeited funds and apply it to restitution? These could be conversations that defense counsel might consider having with victims counsel if there is a situation where victims have counsel and say, hey, my client's funds were forfeited. Why don't you, victim, go seek Department of Justice to take those forfeited funds and give them to you? They may not listen to me, but they may listen to you, the victim. So that's a really important consideration to bear in mind, because otherwise there's a very, very realistic chance that in a case where there are out-of-pocket losses to victims and forfeiture, that you will be in a situation where you may have to pay twice. I think I will just make two other points, and I don't want to use up all the time here. So one, there's a pending case before the Supreme Court on the issue of restitution. It was argued in October, and this case tees up an issue as to which there is a circuit split, specifically whether restitution is a criminal penalty or a civil remedy. It is sort of, courts have split on this issue. And I think Margaret was saying earlier, like, forfeiture is punitive, and that is what it is intended to be, to make you sort of cough up anything you got to which you weren't entitled, whereas restitution is to make victims whole. That said, a number of courts across the country have said that restitution is a penalty. It feels more like a criminal penalty, and obviously there's a more complicated analysis. And other courts have said, no, it's not. This issue, I expect, will be resolved this term of the Supreme Court. And I think it seems like it's likely to be to come out by what it seems that the likely ruling will be that it is a penalty and not a civil remedy. And if that is the case, that could raise a host of other constitutional concerns that will provide certain arguments that could be available. So one of the things I mentioned very early on was that restitution is determined. It's determined by a court, and the burden of proof is a preponderance of the evidence. So it's a much lower burden for the government to prove than a criminal case. If ultimately the Supreme Court rules that restitution is a penalty, there are arguments that the Sixth Amendment right to a jury attaches to findings as to restitution. So I don't know how realistic any of these issues are, but there are real arguments in the makings about why the entire restitution process is potentially unconstitutional and will need to be reframed. So that's just more of a stay tuned if you have a case on the horizon. There's a lot more I could say, but I'm going to stop for now and turn it over to Caroline, and we'll go from there.
Jillian, thank you. And thank you, Margaret. You guys teed this up well. Margaret, I know that you have a hard stop right before 8 o'clock. There are a ton of questions in the chat. And so I don't know if you've been monitoring those, if there's anything you want to say. I can say one question is whether a forfeiture judgment in a criminal proceeding has a lifeline or a lifespan, I guess is a better way to put it. Is it 20 years? Can it be renewed like a regular judgment?
My understanding is that they're enforceable indefinitely. I think it depends how it's framed. If it's framed as a money judgment, it may expire and be renewed. You are seeing right now one of these funny things that Jillian talked about, which is the way all of this is compartmentalized
Yes.
in the Justice Department, which is why, you know, defense attorneys and defendants need to do a little bit of their own research, because as an AUSA who handled forfeiture for 11 years, I was never involved in the collection part. And so I actually am not sure. And that is
No,
my
you're
best
absolutely
memory.
right. Boy, that I think that covers so much of our topics. There's so many issues here, and so much to unpack. So there's plenty of questions there. We can always do a part two of this or provide additional information after the fact. I know you're going to have to jump. I will just launch in if that's all right. And you guys covered so much, which is great. Let me pull up my notes here. Um, so first, in terms of restitution, I just want to reiterate, one, the primary purpose of restitution is to restore the victims. So it's limited to actual loss. And who is a victim and who isn't a victim is certainly ripe for discussion, both with the government during plea negotiations and if there's a conviction after a trial during a sentencing proceeding. So you can raise that in your sentencing memorandum, challenging what the government is claiming for restitution. You could have a hearing on that. The burden, even though most victims will go through the government to put in their claim, the government is supposed to do a good faith check of those claims to make sure that the harm is not too attenuated. It needs to be related, right, to the proceedings and to the defendant's conduct. And so the government bears the burden of proof. Now, it's a preponderance of the evidence, not beyond a reasonable doubt, but it bears the burden of proof to establish victims. And I saw that someone put in the chat, Steve Keller, thank you very much, the Xander case that talks about when victims are misidentified. As a general rule, once a restitution order becomes final and all appeals are exhausted, it's a final order and there's no way to challenge it down the road. I have to take another look at this Xander case to see if there was a lot of daylight between the judgment and that ruling. I believe it was on appeal, direct appeal. Steve, maybe you can tell me if I'm wrong about that. I know you're on forced mute, but maybe in the chat. But it's important that restitution be understood as something very different from forfeiture. Let's talk a little bit about the collection of restitution. So this is general. I'm talking general rules, not tax rules at this point. So as a general rule, an order of restitution will be part of the judgment that's entered in a criminal proceeding, either as a result of a plea negotiation, a plea agreement, or a conviction following sentencing. And the judgment is going to be subject to collection by the tools that the government has available. And it can be enforced against most property and rights to property that a defendant has. There are some exemptions, but they are limited. So, for example, if you look under section 3613 little a, it says that certain properties are going to be exempt from levy and they're going to be tied to a section in the Internal Revenue Code 6334A and then a series of numbers. So let me just rail off what's exempt, what you can keep away from the collection efforts. Wearing apparel and school books, items necessary for the taxpayer or their family. And when I say taxpayer here, I'm going to substitute defendant, but this is from the code, the Internal Revenue Code. Fuel, provisions, furniture, and personal effects. So your household items, your livestock, if you own a farm, up to a certain specified value, items for personal use. Your books and tools of the trade or profession. So if you are a mechanic, they're not going to come and steal your truck and all of your tools and force you not to be able to earn a living. Your unemployment benefits are exempt. Your undelivered mail is exempt, believe it or not. Certain annuity or pension payments, and those are specific. We're going to get to the ones that are not, but benefits under the Railroad Retirement Act, the Railroad Unemployment Insurance Act, the Medal of Honor pensions, and certain military pensions are exempt. Judgments for support of minor children, those funds to support the children are exempt. Certain service-connected disability payments, so military service, and then assistance under the Job Training Partnership Act. So there's a bucket of things that you can say, hands off. This is mine. You can't get to it. Unfortunately, if you've ever been through a bankruptcy, you know that there are certain things that are exempt under bankruptcy rules. They do not apply when the government is trying to get restitution. So you're not going to be able to exempt like homesteads or exempt property under Title 11 under the bankruptcy code. That does not apply. Then the government giveth, but they take it away. So at first, the government says, we're going to apply the thresholds under the Consumer Credit Protection Act. So if you're earning wages, you're going to have a portion that is exempt from garnishment to collect a restitution. And the way it reads is 25% of your disposable earnings for the week, or the amount by which your disposable earnings for that week exceed 30 times the federal minimum hourly wage, whichever is less. So they're going to give you a portion of your wages. Now, we all know many people have to work 3 jobs to pay their bills these days. So this is small comfort, but there is an exemption to that, and you want to make sure that you're fighting for that. It does not apply. There are exceptions. So this is where they giveth, the government giveth, but taketh away. It does not apply if there is an order for support of any person. So if the defendant owes child support, they're going to have to pay that. They don't get to kind of say, I'm not going to pay out that support. And it doesn't apply to state or federal taxes. So you're going to have your taxes withheld. Okay, some bad news. The government can collect from retirement accounts. Under the Mandatory Victim Restitution Act, the government's authorized to enforce restitution orders in the same manner as tax levies. So they can go after retirement accounts such as IRAs and 401ks. That is notwithstanding any exemptions under the ERISA rules. Now, the government steps into the shoes of the defendant. So if the defendant is not entitled to a lump sum payout from their, say, 401k or their retirement plan, then the government can't go in and be like, I would like to elect a lump sum payout. They basically stand in the shoes and they're entitled to grab what comes out in the normal course, whatever the defendant is entitled to. They can, and this applies, as I said, to IRAs, 401ks, and SEP plans. As Jillian noted, there is a 20-year limitation on an order of restitution that cannot be extended, even if the government files a motion on the eve of the 20 years to enforce the restitution order. So there is case law that says that does not get extended beyond the 20 years. That's some good news, although I know 20 years is a long time. So if you have a restitution order and 20 years has passed, there are some proactive things that you should be doing to protect yourself. One, get written confirmation of the lien termination. Okay, so you want to reach out to the government, to the U.S. Attorney's Office, and to their FLU unit and get written confirmation of the lien termination. You want to verify with your credit reports and in property records that any recordation of the judgment of restitution has been properly released, and to the extent that you're able, to seek legal advice to kind of scrub your financial landscape. Make sure that this isn't out there anywhere, because if it's out there, a creditor might, someone may try and act on it, or you might be denied a loan or employment as a result of it. You want to take proactive steps to clear this from your record. Okay, somebody asked about foreign assets in the chat. If there is a restitution order in the U.S., the government, the United States, can reach overseas to try and collect that. They do that through treaty relationships with their foreign treaty partners. You may be familiar with something called an MLAT, a Mutual Legal Assistance Treaty, and there are provisions in those agreements that allow one government to help another government collect on these judgments, and each treaty is different. But they have to go through those rules. There are cases where foreign governments have had an order and they've reached out to the U.S. and the U.S. has helped, like, for example, Brazil, to collect on a judgment from U.S. situs assets. So they can reach out overseas. Okay. So those are the general rules about collecting restitution. It's a judgment like any other federal judgment, but a bit on steroids because the exemptions are more narrow. Let's talk a minute about tax. If you have a case where restitution was ordered to the IRS, to the Internal Revenue Service, that's going to result in an order of restitution, a judgment, as part of your criminal sentence or your family member's criminal sentence. In addition, under Section 6201A4 of the Internal Revenue Code, the IRS has the ability to now assess that amount of restitution as if it were a tax. And then once it's assessed, and that's called a restitution-based assessment, we call it an RBA for short, that can then be collected using all of the collection tools under the Internal Revenue Code. So notices of federal tax lien, series of collection notices, liens and levies, garnishments, all of those tools that are available to collect a federal tax are now available to collect a restitution-based assessment. The good news is that if you've only been charged with Title 26 tax offenses under the Internal Revenue Code, then restitution is not mandatory. You can agree to it in a plea agreement, and oftentimes defendants will agree in terms of negotiating a plea, and most prosecutors are instructed by Main Justice in DC, make sure that you put a restitution agreement in your plea agreement with the defendant. But if a defendant just goes to trial on a tax evasion charge or a false return charge or failure to file charge, and they get convicted, restitution cannot be ordered as part of the sentence for strictly Title 26 offenses. Now, if someone is charged with conspiracy to defraud the Internal Revenue Service of the United States by impeding or impairing the internal revenue laws, or they're charged with making false claims. So, for example, people do fictitious refund claims, and that's a Title 18 offense. Then restitution can be ordered. Even though it sounds in tax, it's under Title 18, so they're going to get that automatic, that mandatory restitution. But if you're convicted after a trial of a tax charge and they can't order restitution as part of the sentence, the judge can still order it as a condition of probation or a condition of supervised release. Not great, but in that case, they can only collect the restitution during the period of probation or supervised release, and the IRS will still be able to assess it as a restitution-based assessment, but they can only collect it during those periods, and then they have to abate the assessment. So that's a case called Westerbrooks, and that's really important if you've been tried and convicted of just a Title 26 offense. The other thing to remember here is that this is the restitution to the IRS is actual tax due. If you've ever been involved in a criminal tax case, you know that tax loss can be more than what you actually failed to pay or received in an erroneous refund. It could be intended loss, like you filed $10 million worth of refund claims and the government caught 5 million of them, but you got 5 million. So you're stuck with the 5 million. That's your actual loss for restitution purposes, even though tax loss for criminal guideline sentencing would be 10 million. So let's say we have a restitution order for 5 million, that could result in or would result in the restitution-based assessment. The other thing unique for tax cases is that if I'm a preparer, a return preparer, and I'm filing fraudulent returns, and I'm convicted of a tax crime, that would often be aiding and abetting the filing of false returns under 7206 too. I can be held responsible and be stuck with a restitution order for the tax owed by the taxpayer. There's clear case law that said I can be charged with third-party tax loss in a restitution order. Okay, couple things to remember about an RBA. One, it can't be assessed by the IRS until all your appeals have been exhausted. So it has to be a final order, not subject to appeal. Once it's assessed, it's almost like an account receivable in the books and records of the IRS. You're going to start getting notices as a result of that. That restitution based assessment will not include penalties and interest. That's the Klein case. It's limited to the tax loss. If the IRS wants to come after you for negligence penalties or civil fraud penalties, more likely, or interest. They're going to have to audit you and then propose a deficiency and those penalties and go through the normal channels, which brings up a good point. Just because the IRS has a restitution order saying you now owe us $1 million for a restitution-based assessment does not prevent them from conducting an audit for the same tax years, the same loss, and proposing an assessment. They can only collect it once. It's not like forfeiture and restitution. A restitution-based assessment for $1 million owed for 2010 and an assessment for 2010 for the same tax is duplicative. They can only collect it once, but they can do both assessments. And oftentimes what happens is they'll do, like, for example, an employment tax violation case, they will have already assessed the liabilities. Then someone will get charged with employment tax violations under 7202. There'll be a restitution order. The normal civil assessment for the tax will expire because that expires in 10 years if there's no tolling. But now the restitution-based assessment hits, and that's another 20 years, even though it's the same tax. It's not double jeopardy. It's just the way the law works. So, it's also not dischargeable in bankruptcy. So a restitution-based assessment is really not a great thing to have because it's not challengeable in a later proceeding. Once it's final, it's final. That number can't be challenged, even if it's ultimately determined in a civil audit that the number was wrong in this criminal case. This is a big frustration on my part. So it's why you need to get your lawyers and your forensic accountants and your other consultants in early in a criminal case to start really working those numbers and getting them down as low as possible for restitution purposes. It's not subject to offer and compromise. You hear about late night TV saying pennies on the dollar. Those are not eligible. Restitution-based assessments are not eligible for those. So don't pay a tax resolution company $5,000 to try and get rid of your $1 million restitution-based assessment. They're just taking your money. They won't give you any results. And they're non-dischargeable in bankruptcy. So don't pay a bankruptcy lawyer that tells you I can get rid of this in bankruptcy. I feel like there are people out there that will prey on people in this situation because they don't have sufficient information. So these programs are good for that. Okay, in addition to the collection issues, oftentimes a restitution order is going to be subject to a payment plan based on the wherewithal of the defendant to pay the amount due. Right? So what do you own? What do you earn? Okay, we're going to have you pay restitution of $50 a month until the restitution order is exhausted or paid in full, satisfied. Many people come out and they make those payments, and then all of a sudden the IRS starts threatening to levy, and they race back to the court or they yell at the IRS and they say, you can't do this. I have a payment plan with the court and you're encroaching on that. I've already got this under, stand back, I'm paying this. The IRS is going to say, we're not bound by that. We have a restitution-based assessment. We can use all the tools we want. You can continue paying your $25 a month, but we're going to seize your IRA, your 401k, and all of that. It's a very difficult situation. The IRS has authority to do that. The cases have come down and there's unanimous rulings on that. So when you're negotiating payment plans and if your counsel is telling you, don't worry, you'll only have to pay this amount a month, make sure you're raising this issue. Like, what do I do when the IRS starts to collect? And that's, again, a good reason to hit these number issues early in your criminal case. As soon as you start talking about a plea negotiation, if that's your situation, you want to start talking about this issue so you don't have this financial burden after the fact that follows you. Okay, deductibility of restitution payments. If you are paying restitution to the IRS, that's not going to be deductible. But if you are paying restitution to, for example, let's say you embezzled from an employer, and during the year of embezzlement, let's say you embezzled all in 2010, you had to report that as income. Now here's 2015, and now you have a restitution order and you have to pay it back. You can deduct those restitution payments because you are restoring the funds to the victim, right? So there are cases out there that support deductibility of restitution payments in the year of the payment. There are rules surrounding this as well, though. You don't get to deduct the restitution if it's a fine or a penalty. Restitution really doesn't fall in that category, except for the fact that we've got this case out there that Jillian mentioned that says restitution is punitive and may be deemed a fine. So this state of law, the current landscape may change down the road. But if you are paying restitution, consider give some thought to whether it's deductible. You don't want to claim it if it's not, because then you're right back in front of the government on a false payment. Okay, let's see. And let's talk just briefly about the tax impact of forfeiture. So we're coming full circle from Margaret's presentation. If you are negotiating a forfeiture order, it is better, I believe, to negotiate in-kind forfeiture as opposed to a money amount. And this is because I'm a tax attorney and I think about tax all the time. And so if I have a money judgment for $1 million and they take my house as forfeiture and my cost basis is only 300,000, but it's worth $1 million, when they take that, I'm going to have 700,000 of gain under a constructive receipt reasoning or analysis by the U.S. tax courts. Now, that may change because we've recently had a case in the Sixth Circuit called Hubbard that may cause people to reconsider that. But right now, the law is that if they take my house and I satisfy a $1 million judgment with a $1 million house, but I have 700 in gain, I'm going to be taxed on that. And I'm not going to have any money to pay it, obviously, because they've already taken the asset that I had. However, if I negotiate an in-kind forfeiture order, it's not $1 million. You just list the house as the forfeiture and you take that, then I don't have gain. And that's Hubbard. That's the Sixth Circuit case that came down in 2025. And as tax counsel, we have been arguing this in our criminal cases for years. So we are thrilled that the Hubbard decision has come down, and we hope that it has some ripple effect in other areas of the law. The other thing with tax, let's see, other issues on forfeiture. I'm trying to think the tax impact. Oh, if there was some talk about, Margaret mentioned if you have, say, $1 million forfeiture order and you negotiate a $300,000 upfront payment and they accept that and they wipe it out as satisfied, do you have cancellation of indebtedness income? You might be familiar with that concept. If you owe somebody $50,000, you get that loan, and you don't report it when you get that money, but then if it's forgiven, you got a $50,000 income recognition event in the year that's forgiven. There's authority out there that says that when that happens with forfeiture, it's not a recognition event. And again, that's another area where the law is developing on a regular basis. So kind of watch this space. Bottom line here, and I could go on and on about restitution-based assessments, is that it's really important when you get into these cases. One, it's like the most horrible time of your life, right? That most people have not gone through this before. We're not talking about recidivists. And so they're dealing with all sorts of issues. And this is the one thing that most attorneys, or let me just say, many attorneys are not familiar with restitution and forfeiture, as we talked about. They're not thinking about that. They're thinking about, how do I protect you and keep you out of jail as much as possible? That's really their end game, right? And so these things get left to the last minute. That's really the worst, because then you are behind the 8 ball. The government uses that as a hammer to try and get you to sign off on a plea that you're looking, saying, well, they're offering me 2 months instead of 2 years. I guess I'll deal with restitution and forfeiture later. At least I don't have to spend more than 2 months in jail. You've got to find the wherewithal to push back. And even if it means talking to your counsel and getting someone else in there to assist. I haven't been watching the chat, so hopefully we could talk. I know somebody asked about Social Security. Social Security is not one of the exempt items, and so they can get a portion of the Social Security. I think there's a threshold level, because under the tax code, there is a threshold of how much they can take of your Social Security when they're levying to collect taxes. And I think it's going to be based on that. But again, when they're collecting restitution, this is also an opportunity for you to go to the government and say, I understand you're collecting it. I can't feed my family. I can't pay my insurance premiums. I can't go to my doctor. We need to work out a payment plan. If you do nothing at all, then you're just going to have it come after you all the time. And they're going to use every tool. But if you engage and have a conversation, we have found that we can usually work out a resolution for clients that is somewhat livable.
That's a lot.
It's a lot.
There's so much that we just threw at you. I hope it's helpful, not overwhelming. We, as you can tell, these are there's a lot of nuance to this. And as I'm looking through questions in the chat, I know answers to some, but not to all, because these are that complicated. Maybe we'll just start scrolling through and try to answer some of the questions.
And Jillian, by the way,
yeah.
I'm going to send you a copy of the whole chat.
Oh, great.
And if it makes sense, you can respond or do whatever you can do. It's very dense, so we certainly don't expect responses to everything. But I want to thank everybody for everything you're putting in chat. Go ahead, Jillian. Sorry.
Great. Yeah, that would be great.
Actually,
Carolyn, yeah.
Jillian, let me just answer one question, because I think Freya has asked several times,
Yeah.
where do you get an audit of the restitution? So if you have a restitution order that's resulting in a restitution-based assessment to the IRS, there is an account transcript that you can get. And if your payments are not showing up on that, then you want to reach out to, hopefully your attorney's involved, but if not, you can reach out to the clerk of the court where you send your restitution payments and ask for a report of all the payments that they've received and evidence that they've transmitted it to the victims. And then you can do it that way. I mean, I had a case where it took me 2 years to trace payments because the clerk put them in the drawer and didn't transmit them to the victim.
I think in that vein too, there's a real problem with all of these components structurally because of the disconnect that we were talking about between the different units and divisions of DOJ that are handling them, et cetera. The clerk of the court is handling restitution payments. Typically, when there's a restitution award, it has to be sent. The payments have to be sent to the clerk of the court. The clerk of the court has a list of victims. I think I don't know the nuances of how they actually do the payouts to victims, but my anecdotal understanding, and maybe you know more than I do on this, but is they wait a certain period of time to collect payments, and then divvy them up. There's sort of, sometimes it's a pro rata depending on how many victims there are. So I don't think there's an incredible process that is employed, despite the fact that it's something that could follow a defendant for 20 plus years. And there's some periodicals, and I think there was a recent study on restitution that came out. I will say maybe a slightly positive note, but I don't actually know. Is that a good percent of restitution awards go uncollected. So I think they are not created equally in terms of the government coming after you to take assets. I saw there was one chat in here about a lien being put on someone's in-laws house to go towards restitution. Some often, I think we mentioned earlier, the FLU unit, financial litigation unit, is often the unit in different U.S. attorneys' offices that is enforcing restitution awards. And they are not all created equal, and they have limited resources too. And some are very aggressive in going after assets, and others are not. I've had decent experience negotiating a payment plan when there's been a very substantial restitution award, at least in a situation where my client does not have a tremendous amount of assets. So it's not like there are, $1 million homes to seize and liquidate and apply towards a restitution award, but there's very limited assets in a bank and a modest home and Social Security benefits coming in. And typically you can, or at least in my experience, I've been able to negotiate a payment plan that is something like 20% of income or some percent of either income, or if it's sort of finite savings and accounts for someone who's older and isn't going to be earning more money. But it's really kind of at the whim and discretion of the different prosecutors that you're dealing with, whether they will negotiate a payment plan and whether they will stay away from taking certain assets, like your home. I think that, Carol, we've talked about this in the past. I think that most prosecutors wouldn't go after, a home that is a modest home where, as long as they don't see someone living lavishly off of the proceeds of a fraud. But if they see that and they think, you may have taken millions of dollars and purchased a fancy home, et cetera, they're going to treat it very differently than the former situation.
Correct. Yeah.
I'm just going to scroll through
There's
some
a
of these.
question
Yeah.
about limitations. I know this is an ongoing thing. There's a difference between the 10-year statute of collections from an IRS assessment, which does apply to a restitution-based assessment, but can be told depending on various events, and the 20-year statute of limitations on a restitution order that is a judgment in a criminal case. So the restitution order that's entered by the court will remain outstanding for 20 years. And case law says that that cannot be extended. There's no statutory authority to extend that. A restitution-based assessment can be made at any time. There's no limitation on when it can be assessed. So it can be assessed 10 years after a criminal case is completed. But once it's assessed, it's subject to the 10-year statute of limitations. And I will tell you that point, 10-year statute of limitation on collection, that is not an easy thing to find in the law, but because there's so many nooks and crannies in the Internal Revenue Code. But the government has taken that position in filings in cases. And I think that's correct, that it's a 10-year statute on the RBA.
Caroline, does the 20-year statute, when does that clock start?
It's under 3613, so it starts either the later of the day the judgment is entered or the day the defendant is released from incarceration. And that's 3613.
Jillian, Caroline, we have 3 more minutes. Is there anything you'd like to say to wrap us up? And then, and also, please tell us how that we can contact you if we'd like to ask you any additional questions.
Sure.
I'll put mine. Go ahead, Jillian. I'll put my name in the chat.
Okay, I'll do mine in a minute. My email is I'll put this in the chat, but it's jberman@lswlaw.com. There's a lot of comments in the chat about complaining about, or not complaining, but bemoaning the system, and those are all justified. I've said it 5 times already. It is so complicated. So few people know it. I know a sliver of it, and I'm here talking to you as a purported, knowledgeable person on the topic, but half the questions in here are things that I would go look up. It's going to be really important to educate yourself with some baseline knowledge so that you can ask hard questions of your lawyers. Hopefully you have lawyers that do care for you and pay attention to this. And it might require a little bit of educating them on this. Hey, I found a couple things to read, and I understand that restitution and forfeiture are very different, and I'm afraid of being hammered twice. And I'd like to talk about this early in a case, and just really being proactive in raising the issues, because then at least your lawyer, if your lawyer is not super educated on some of these topics, they can go do the work. And one thing I mentioned earlier, which is an important thing to think about. If you have victims in your case such that there is likely to be a restitution award, you and the victim are aligned in getting forfeited assets back to the victim.
Yes.
You both want that. I do find the government very frustrating in this regard, because despite all the talk and the government always says victims come first, and let's make victims whole. And remedy their wrongs. And yet the forfeited funds are, which someone asked, where do they go? They go into a pot of money at Main Justice or the Department of Treasury. They're used for all sorts of things. At the U.S. Attorney's Office in Manhattan, my understanding was forfeited funds would come and fund, fund training, fund resources for the office. They are so rarely returned to victims, even where there is a restitution order. And so I would say, like, that is one thing to think about really early, is how do we incentivize the victims to be advocating to get that money back? Because the government and the prosecutors will listen to victims in a way that they may not listen to your lawyer or you.
Yeah. And I would say a couple things. One, if you do receive a pardon, and they're going out to quite a few tax offenders these days, a pardon eliminates the restitution order, right? So now it does not eliminate a civil tax assessment. It doesn't give you a free pass or let you opt out of the tax system, but it will eliminate the restitution order. And the other thing you can do when you're negotiating a resolution or you're proceeding to trial is do everything you can to pay down as much as you can of what you owe, because you can push back on a restitution order. I've had clients liquidate assets and pay what we think they owe in terms of the loss in a tax case, and then convince the court there's no need for a restitution order here. Like, they've paid it. To the extent that there's anything left over, the IRS will do its job, maybe audit, and they can go through the normal process, but there's no reason to clog up the financial litigation unit and everyone else involved with a very complex and often subject to challenge restitution order. So it's all about getting ahead of this.
So, Jillian, Caroline, we couldn't be more grateful to you and to Margaret. I'm just going to make one overall kind of statement, and then please feel free to react to it. The world has changed a lot over the last 10 years as to these laws and defendants, and still, when we are arrested, there's seems to be an almost singular focus by attorneys as to how much time that we're going to spend in prison or not. And what our experience is that under all kinds of laws, First Step Act, RDAP, during the pandemic, the CARES Act, things like that, people are spending less time in prison than they might have expected. But the financial aspects of the case can be life sentences. So the advice that we give in our support group is get the experts in there early and do the hard work you need to do to understand all the financial aspects, and arm yourself with the best you can so that you're negotiating the important things, or the things that are important to you, so that you don't get surprised later on in the case. Any thoughts about that?
I agree. I would say that the restitution component is a bit of a gamble because you don't always know what the victims are going to come forward on. And so you can negotiate. I mean, I've seen it, and I've did it as a prosecutor, but that was a long time ago, where we negotiated restitution. But that is very risky because technically the government can't, agree to cabin a victim's loss. So I think you can absolutely negotiate forfeiture. And the government will routinely do that. And you might often see like a very big forfeiture order that encompasses what sort of some of the examples Margaret gave, but if there's a $3 million kind of $3 million were involved in the fraud, and there might be a forfeiture order in that amount, but the government might let you satisfy it with $50,000 if you pay it by a certain date. They have discretion to do that. And I would talk to them very early about forfeited funds being applied towards restitution, even though they can't confirm or agree. You can ask them to make a recommendation. You can put it before the court to say, Your Honor, this is really unfair. My funds were, figure out the best way to present it so that they don't so that it's most compelling. But I think judges find the concept that forfeited funds are not applied to restitution to be pretty disgusting, right? Because where is that money otherwise going? It's just staying in the Treasury Department. So I think that those are all very important things to do early on, recognizing that you may still be surprised at the end of a case when, that corporate entity that claims to be a victim says, "Hey, I'm owed $3 million that I had to spend in legal fees."
Mhm.
And someone else I think wrote in the chat about that issue. Think carefully. Is that person or entity really a victim? Are they really entitled to restitution under the criminal statute? So I think all of what you said is right, Jeff. And I'm happy to hear that prison times seem to be shorter. So that's the positive, but this is, I know, very difficult.
Yeah. I would just, one last point on that. If you have multiple victims, and most of my cases involve government agencies as victims, but if you have multiple victims and you want to mitigate against a lot of legal fees for multiple victims, and you want the victims to help you with a restoration effort, you might want to consider, if you have the wherewithal, getting pool counsel and advertising, reaching out to these victims and saying, "Look, I'm sorry. I want to help you recover. I'm probably going to have this forfeiture order. There's this process. Can you help me help you? Send me your information. Let me put together a package. Let my counsel try and push for restoration after the criminal proceedings." That would actually eliminate some of the independent legal fees that some of these folks might feel they need to incur in order to rush up and be front in line. So it's just another tool that can be used when you're thinking outside the box to deal with these issues.
Wonderful. Jillian, Caroline, thank you so much for your time tonight and your wisdom. What a wonderful, wonderful presentation. Thank you so much. And thank you to the Women's White Collar Defense Association in general for your support. I hope we can do a lot more events together. Blessings to everyone. Thank you for being here tonight, and have a good night. We'll see you next time.
Thank you, everybody.
Thank you all.
Have a good night.
Good night.